charges.
So what's Weisselberg's legal team saying about this?
Well, in a statement just now, his attorney, Nick Gravanti, said that this was one of the most difficult decisions that Weisselberg has ever made, but he wanted to put these years of what he called a nightmare behind him. He had faced the possibility of 5 to 15 years in prison, and in a way he still does if he does not testify truthfully at the upcoming trial of the Trump Organization, which was charged with Weisselberg in this compensation scheme. The guilty plea from the former chief financial officer certainly implicates the company, and it could be very hard to defend the company against these charges when it comes time for trial in October.
So, Aaron, how could this guilty plea affect that upcoming October trial against the Trump Organization, and could it have an impact on that parallel state civil investigation?
Alan Weisselberg was instructed by both the prosecutor and the judge that he must testify truthfully at trial. He's already admitted to all of this fraudulent conduct, and he was charged right along with the company itself. So Weisselberg is going to have to give what the Manhattan District Attorney called important testimony at the upcoming trial of former President Trump's namesake company. But this does not include any cooperation agreement by Weisselberg to turn on Trump himself. Trump is being investigated as part of a wider criminal probe into his business dealings, and Weisselberg is not going to flip on him.
All right, got it. Aaron Katersky outside the Manhattan courthouse for us. Thanks, Aaron. And let's bring in ABC News contributor and host at the Law and Crime Network, Brian Buckmeyer, for more on this. Brian, what does this guilty plea by Weisselberg do for that upcoming trial? You heard Aaron say he now says he will have to testify in that trial and testify truthfully. So what does that mean for the Trump Organization?
Well, it means that the Trump Organization is going to have to combat the district attorney's star witness. This is a witness who has allocated to multiple counts of charges that is the connective tissue between his allegations of guilt and that of the Trump Organization. And so for the defense, how are you going to defend the Trump Organization when the CFO, the person probably more knowledgeable about the tax implications than anyone else in the organization, has already pled guilty and is now incriminating your client?
Now, Weisselberg did not agree to cooperate in the criminal case against Trump himself. So how vulnerable is the president without that cooperation?
It's degrees. If we're talking about a scale of 1 to 10, the full cooperation of Weisselberg might have been closer to a 9 or a 10, but not cooperating, but still pleading guilty and agreeing to testify, you're talking about somewhere around a 7. And so it's bad, but not as bad as it could be. The allocution, and that's the answering of those yes questions and going through what the charges are and then promising to testify. It's bad. It could be worse, but it's still bad.
I also want to ask you about this federal case. A judge in Florida is currently hearing arguments about whether to unseal the affidavit behind the Mar-a-Lago search. What would this affidavit tell us, and why would Trump and media organizations want it released?
All right, so an affidavit in its core is when law enforcement goes before a judge and swears or affirms under oath and provides probable cause and particularities. Particularities being, here is what we're looking for, here is what we'll find it, and this is how we got to that information. So these are the details of which the search warrant is predicated on, and this could go to who was in Mar-a-Lago at the time and saw these documents and saw how they were handled. Maybe they're talking about seeing the documents themselves, and so everyone wants them released because this gives us the full story, the full breadth of why this search warrant was allowed. It's kind of like looking at the judge's notes as to why he permitted it.
Now, what can we expect from today's hearing? What is the judge looking to learn today to make this decision of whether or not to unseal all or part of the affidavit?
This is going to be a huge balancing act between, on one side, the integrity of investigation, because a search warrant is the beginning. It's not the end. And the need for public interest to hear what is going on behind closed doors, because typically A search warrant isn't open to the public or even defense attorneys until after an arrest and an indictment. So to do it beforehand is very unprecedented, but considering the magnitude of this search warrant, it's understandable. Now, the devil's going to be in the details as to what is and what isn't redacted, because you can redact names, but if you say X was in Mar-a-Lago on Tuesday at 5 p.m., that simply allows everyone just to go back to the video and see who it was. And so you have to redact in a way that is protective of the investigation, but also gives the people enough information to legitimize a search warrant.
So where does this investigation go from here?
So the next step is who saw the documents? Who were they privy to? The kind of chain of custody that people have been talking about. Because at least for the purpose of the investigation for the 3 charges that were levied against the former president, whether or not those documents were confidential or secret is not really the issue. Now I think the investigation goes to what else occurred? Who saw these documents? How were they handled? Were they destroyed in any way? And so really it's about chain of custody and looking at those videos that were subpoenaed to see what in fact happened to these documents.
All right, Brian Buckmeyer, we appreciate your legal analysis as always. And we also wanted to say congratulations.